Be ready? 5 seconds. Start. The court went into the question as to whether interlocutory injunction of a mandatory character as against the prohibitory injunction could be granted question mark. The counsel for the respondents pointed out that the mandatory injunctions were essential to avoid greater risk of injustice being caused. Stop. There is no difficulty in accepting that this court did accept that test. Stop. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining. Stop. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause great injustice or irreparable harm, courts have evolved certain guidelines. Stop. Stanza. From a perusal of the inspection report dated 12 to 2004, it is clear that there is no finding recorded by the sub-registrar to the effect that the building was in existence prior to the date of the sale deed. Stop. On the contrary, the petitioner has taken a specific case before the authorities below that the construction was made after the sale deed was executed. Stop. In support thereof, the petitioner had submitted the plan of the architect prepared after the sale deed and also produced her bank passbook to show that withdrawal to the extent of about rupees 4 lakhs had been made by her after the sale deed had been executed, which amount was utilized for the construction on the plot. Stop. She also filed her affidavit as well as that of the contractor in support of her case that the constructions were made after the sale deed was executed. Stop. However, the authorities below have relied on the report of the sub-registrar and held that there was deficiency in payment of stamp duty without even recording any specific finding that the constructions were made prior to the execution of the sale deed. Stop. It is not the case of the respondents that the land in question was undervalued. Stop. An inspection was got done after 10 months of the execution of the sale deed. Stop. It is also not the case of the respondents that the constructions found on the date of inspection could not have been made within the period which was after the execution of the sale deed and till the date of the inspection. Stop. For imposing liability for payment of additional stamp duty, it would be the duty of the respondents to categorically show that there was some concealment made by the petitioner at the time of execution of the sale deed. Stop. On mere presumption that constructions existing after nearly a year must have been existing at the time of execution of the sale deed, stamp duty cannot be imposed after valuing the constructions without giving a categorical and specific finding that at the time of execution of the sale deed such constructions had existed. Stop. It is settled law that market value for the purpose of determining the stamp duty has to be determined with reference to the date on which the document is executed and not on the basis of any improvements made on it thereafter. Stop. The sub-registrar or the authorities concerned should have verified the same prior to registration of the sale deed or immediately thereafter, but imposing liability for payment of additional stamp duty on the basis of a report submitted after nearly an year of the execution of the sale deed, during which period admittedly such constructions could have been made, would not be justified. Stop. As such, the orders impugned in this writ petition are based on no sufficient evidence to show that there is any concealment of any material fact on the part of the petitioner, or that the petitioner had purchased the plot with constructions. Stop. Accordingly, this writ petition stands allowed. Stop. The order dated 17/10/2005 passed by the additional collector and the order dated 22/6/2006 passed by the Commissioner, Meerut Division, Meerut, are quest. Stop. In case if the petitioner has already deposited any amount in pursuance to the interim order passed by this court, the same shall be refunded to her within a period of 2 months from the date of production of a certified copy of this order after the respondent number 2. Stop. In case if the amount is refunded within the said period, the petitioner would not be entitled to any interest. Stop. However, in case of default in refunding the amount to the petitioner within the aforesaid period of 2 months, the petitioner shall be entitled to interest at the rate of 12% per annum from the date of default till the date of actual payment. Stop. Stanza. The case of the petitioner is that under the service rules, the period of probation prescribed is 1 year, and since no order was passed extending the period of probation, and consequently he would be deemed to have been confirmed in December 2000. Stop. It is urged that the probation could be extended by a maximum period of 3 years, which expired in December 2003. Stop. Thereafter, his services would be deemed to have been confirmed. Stop. There was no justification in not confirming him in the year 2005 or in postponing the issue relating to confirmation on the ground that his services had not been found to be satisfactory. Stop. It is urged that the same mistake was committed when the respondent refused to confirm the petitioner in October 2007. Stop. It is further submitted that at the relevant time there was no adverse entry in preceding 5 years. Stop. The solitary adverse entry of the year 2001 to being an entry more than 5 years old could not be made basis for not confirming the petitioner and in denying promotion to him. Stop. The warning issued by the Registrar General by order dated 12/6/2007 also could not form basis for withholding confirmation or denying promotion to the petitioner, in as much as a warning is neither an adverse entry nor a punishment under the service rules. Stop. It is pointed out that a preliminary inquiry in another matter, which also formed the basis for denying confirmation, has culminated in favor of the petitioner, and thus the same could not have been the basis for denying confirmation in service. Stop. Stanza. The writ petition was opposed by learned counsel for the respondent by contending that under the service rules, although a maximum period of probation as well as extended period of probation are prescribed, yet there is no provision of deemed confirmation. Stop. It is submitted that the appointing authority is enjoined with the duty to assess the suitability of a candidate, and he is confirmed only if he is found fit and his integrity is certified. Stop. It is urged that in the case of the petitioner, his work and conduct was not found to be satisfactory. Stop. It is submitted that in the year 2001 too, there was an adverse entry against the petitioner followed by another adverse stop over.